I had a jury in the trial of Plaintiff Jennifer versus defendant AU Hospital. In this case, the defendant contends the hospital failed to determine that a reasonable effort was made to ensure that she received notice of the request of her information. The plaintiff also contends the hospital failed to ensure that the party requesting the information made reasonable effort to secure a qualified protective order. According to www.hhs.gov, covered healthcare providers or healthcare plans may share your protective health information if it has a court order. This includes the order of an administrative tribunal. However, the provider or plan may only disclose the information specifically described in the order. According to the Privacy Act, CFR 164.512E, when a court order is received, a covered entity such as a hospital may release records specifically with no further process required. However, in this case, the defendant stated that a subpoena was received by the hospital, but the defense did not state if it met the Privacy Act requirements. The plaintiff attorney addressed the HIPAA privacy as well on behalf of the plaintiff, which stated providers or health plans may disclose information in the event of a subpoena only if the notification requirements of Privacy Act were met. Before responding to the subpoena, the provider or plan must receive evidence that reasonable effort was met as follows. 1. Notify the person who is the subject of the information being requested. 2. So the person has a chance to object to the disclosure of information. Or 3. Obtain a quality protective order for the information from the court. The defendant also stated that AU Hospital had a policy in place regarding sharing PHI and confidentiality of patients, even though the hospital stated that they made numerous attempts to reach the plaintiff and was unsuccessful, but yet they still disclosed the plaintiff information without receiving the proper requirement to do so. If the hospital have a policy in place as well as the HIPAA and the Privacy Act law intact, why was the plaintiff notified? Why wasn't the plaintiff notified the proper way? Although the defense for AU Hospital believed they did no wrong because the requesting party was indeed a government nature. However, because the defendant failed to specify which type of government agent to support the defense case, cited the 1974 Privacy Act and the exemption of releasing information to either law enforcement, congressional investigators, or the Department of Homeland Security. The defense never stated that the government agent requesting the information was one of the three mentioned. It was not clear to me if the subpoena fell under one of the 12 Privacy Act requirements. The defense also failed to state the purpose of the requester and the detailed information requested. Therefore, the defense failed to provide evidence that the subpoena received met both the HIPAA and Privacy Act requirements. The plaintiff attorney also addressed that her client was not contacted nor was she notified of any request for her to authorize the release of her medical record. The plaintiff attorney listed in detail all the information that was included in her client's record when the hospital released her client's records. When the plaintiff testified in the matter, she presented her feelings through voice and her emotions. As a patient, the hospital entrusted with patient care and responsible for handling and protecting all healthcare information. The plaintiff clearly states in detail of the type of information was shared, such as phone number, address, social security, and elite. Because of this violation, the plaintiff no longer feels safe. However, the defense still argued that AU Hospital did no wrong, but yet still apologized to the plaintiff. Therefore, I would have to take that the defendant is acknowledging some fault on their behalf. Therefore, I would have to find the defendant guilty as charged and rule in the favor of the plaintiff. Thank you.